discriminations are outlawed. And the petitioner was asking the court to declare those provisions unconstitutional because they are ambiguous and because they discriminate against people who have same-sex orientation or attraction. The court ruled that those provisions are not ambiguous. Everyone knows what they mean, which is that people who engage in same-sex behavior are committing a criminal act. And the court also ruled that there's no discrimination because the provisions apply. The sexual orientation is not the same thing as sex. Sex is what discrimination on the basis of sex is what is prohibited. In other words, on the basis of gender.
So if they're continuing to appeal, what's going to happen next?
So the petitioners have 14 days to give notice of appeal in the event they want to appeal. And then after that, they have to compile all the documents that were used in the trial court and then prepare what we call a record and a memorandum of appeal. Once that is done, the matter will go to the Court of Appeal. The Court of Appeal is composed, they hear cases either a bench of 3, 5 or 7 judges. Once the Court of Appeal makes a decision, whoever is dissatisfied has a further right of appeal to the Supreme Court of Kenya. The Supreme Court is the final court for determining constitutional questions if the party chooses to appeal.
I have a question, Mr. Kanyama. The petitioners frame this often as a colonial era law. Do you think that the court decision today reflects the idea or the belief of the court that in fact this is it's not just a kind of a colonial era kind of decision, it's actually they're looking at the current events today? How would you react to kind of the sort of the timeliness of this?
Yes, so the Penal Code of Kenya was first enacted in 1935 in our colonial period, and it has been amended numerous times in the 56 years in which Kenya has been independent. So there are many provisions that have been changed. Even this section 162 has been amended. So it's not, the provision doesn't exist the way it existed at colonial times. Kenyans have been able to change what they did not like about the Penal Code. But just to give a context, the Penal Code contains over 200 penal offenses, including murder, treason, robbery, fraud, all kinds of offenses. So this is just one of the offenses that are there, and we have been amending the ones we think we need to amend and retaining the ones we think we need to retain.
But as to the argument that these particular penal codes are ancient history, you would say that's not true. It's a living document. It's a document that the legislature has not amended, and would you therefore say it's it reflects the current times?
I say the Penal Code has been amended numerous times since independence. So in other words, the amendments have brought it up to date to contemporary expectations. And the reason why the provisions on sodomy remain is because Kenyans, by a vast majority, over 90%, support those provisions. So it's not because it's an imposition. Our parliament can amend any law very easily. First reading, second reading, third reading, and the law is amended. But they don't want to amend it.
So you disagree?
Laws that date back to Victorian times. In America, there are laws that date back to 18th century, but they keep getting amended. So I think it's a mischaracterization that is more emotive than factual to say colonial era relic. Our laws have all been brought up to date and we continue doing it. We have a robust legislature, a National Assembly and a Senate. People can make recommendations for amendment of any law. And if any amendment is made on this law, it will be, in my view, rejected by a majority of parliamentarians because they support the prohibition against sodomy.
Thank you very much.